denied the application due to inaccuracies in affidavits. We find issue with the trial court's denial, trial court proceeding with the hearing without counsel present, and improperly considering evidence in violation of evidence rules. Counsel filed a petition for approval on July 12th and 14th, 2023, and the first hearing was held in November 27th, 2023. This hearing was purely an application for approval for bonding companies and thus followed the bonding company statutes only. The court ultimately took the matter under advisement and offered to sign an order to force counties to comply with the request for good standing letters in their local rules. We were ordered to come back again in January and were told by the judge he was not ready to proceed. We then go back in March and had a hearing and were ordered to come back in April, where the business day before the state filed an amended response to petition for approval to write bail bonds. The day of the hearing, April 22nd, counsel for the bonding company filed a response. At the hearing, the court ordered the state to gather their proof within 30 days and come back on June 7th. Counsel on this April 22nd day informed the court that she had been declared a high-risk pregnancy and may at any time be told by her doctor she could not travel. Counsel asked the court if that should happen, if Zoom would be an option. The judge hesitated and ultimately said that they would expect counsel to be there unless physically unable. Unfortunately, the week before the hearing, the June hearing, counsel's health took a drastic turn and could not be present. Counsel informed the courts twice of this and asked for a Zoom link since she was medically ordered to stay close by to certain area hospitals. Counsel never heard from the court in the state. The state in its brief states that the trial court did not respond to those emails and thus had notice of the lack of ability to appear in person. Counsel next heard from the trial court when an order was granted denying the bonding company's application due to inaccuracies in the affidavit. Counsel tried to correct various inaccuracies and was again denied as she could not appear in person, and even sent in a doctor's note that stated if she drove that far, she would bleed out. We contend that the denial of the application due to inaccuracies in the affidavits is incorrect. The company submitted new ones that expressly stated that Mr. Brian Cole did not declare bankruptcy under 4011-317C. This court contends there were inaccuracies, and we contend that there were not. Even if there were, there is no basis to deny Mr. Cole and his company based on bankruptcies not covered under the statute. We contend that the trial court improperly proceeded with the hearing on June 7th without counsel present. Statutes determine when a bonding agent may proceed in court without an attorney, and this was not one of those times in TCA 4011-302.
Let me ask you this.
Yes.
You don't file bankruptcy under TCA 4011-317. You file bankruptcy under the bankruptcy law of the United States. And the question as I read it, have you ever filed bankruptcy? And one or both of the owners answered it. One of them, I have never declared bankruptcy, and the other one, I have never declared bankruptcy, and he cited the state statute, correct? Mm-hmm. So, did Mr. Holmes file bankruptcy?
No, Judge. It was only one individual, and that would be Mr. Cole. And under the statute we're proceeding under for bonding company approval, it says only the disclosure of bankruptcies that result in a final forfeiture being unpaid. That is it. And in the same statute, it says to declare all criminal history.
Was that the question that was asked at the hearing, though?
Which hearing?
The one where he testified that he had never declared bankruptcy.
No. It was asked of, have you ever declared bankruptcy? And my understanding is he understood it as under the bonding company statutes, because we were here only under bonding company approvals.
But the bonding company statute was never referenced when the question was asked. The question was very simply, have you ever declared bankruptcy? Am I correct about that?
Correct, yes.
And he said he had not.
Correct.
And that was inaccurate.
That was inaccurate.
Well, then I want to ask you about 4011-307. If after investigation the court finds that the bondsman has failed to furnish the court with information touching upon solvency when called for, the court may order that that bondsman be prohibited from executing bonds, bails, or other undertakings. Isn't that what happened here?
No, Your Honor. During that time between the April hearing when the state brought up an issue with this and the June 7th hearing where it was going to be brought, the state failed to furnish significant evidence showing that there was some question in solvency. And then we get to the June 7th hearing where counsel could not be present, could not fight the objections on it. Specifically, one item, we looked on the bankruptcy court's website. It was so old, they've purged those files, so we have no idea where this document even came from. Again, counsel could not be there to object to the entrance of this. As shown in the exhibits, there's not a certification from any of them. There's no seal on it that says that this is an original one. So, and with that statute specifically, I feel that that is more for if a bonding company is already approved and they haven't been paying final forfeits, hey, let's see your financials. In this case, it was provided that it was insurance-backed, and the insurance company provided their financials. So there was no question that any bonds could have been paid. So we feel that that adequately covered it.
So am I hearing you say you're not conceding even at this point that Mr. Cole has filed bankruptcy?
We're not conceding at this point just based on the documents that were in there because they haven't been authenticated. We have one document in there about his financial status that was a screenshot from a computer. I have no idea where that came from or whose that is. Brian Cole is a very common name, so unless there's authentication, I cannot agree to the authentication of it. It sounded like a very criminal defense attorney answer, but with the documents that were submitted, there's nothing in there that proves authentication or anything that complied with the evidence rules.
How is it not a problem, though, that he was asked point blank, have you ever declared bankruptcy? And he said no. That's a pretty straightforward answer. You know, you take an oath to tell the truth, the whole truth, and nothing but the truth. If that was really what he was thinking, I've never declared bankruptcy, subject to the terms of the statute, shouldn't that have been his response, him being under oath?
I would say hindsight's 20/20, and his understanding probably was we were here purely for a bonding company application. That's the only one he has to disclose.
I mean, aren't we getting a little cute with the proof at this point? Where he's saying, I never declared bankruptcy, and then, oh, wait a second, we need to file this affidavit that says, I've never filed bankruptcy where there was forfeitures outstanding. And now we're saying, well, I don't even know where these records came from.
I think we could be getting that way, but ultimately, if the state is alleging and saying all these matters, they have to ultimately prove them. And, you know, still to this day, we have no idea where this tax lien of $266,000 could be. He's never had one against him. So even the bankruptcy aside, we're talking about something else completely that we have no idea where it even came from. So even if this was remanded back down to the trial court for a proper hearing with regard to evidence, I think we could then dive into that better. But ultimately, the court proceeded without counsel present, without being able to properly object. They had the county clerk here just testify that she did a financial overview on Mr. Brian Cole. Didn't say where it was, but it was ultimately a screenshot that we cannot even verify was the proper Brian Cole.
Had the company filed a motion to continue the hearing?
No, we had emailed the court 2 days, I believe, 2 business days before, and then ultimately a business day before that, counsel could not appear and did not hear from the state or the court. So emails have been sent to the judge's assistant and to the state, and they were both aware. Obviously, the judge was aware by making comments in the record about it, but leaving out the part about medically unable to be there.
Yeah, and this is uncomfortable, obviously, to
Yes,
talk
Judge.
about, and I'm certainly appreciate that fact. But also, wasn't there a statement in the record where it was my understanding counsel basically said, just rule on it one way, we want a ruling one way or the other. So you have that coupled with the failure to file a motion to continue the hearing. I don't know if Judge Allen checks his email every night. I don't know if he has it on his phone like I do. I mean, but that's not an official communication with the court. I mean, at that point, wasn't it acceptable for Judge Allen to proceed with the hearing as scheduled?
I don't think to proceed with a hearing as scheduled. I think with the proof already submitted, he could have done an order denying it as, hey, we're going to deny this at this point, but allow for an opportunity to reopen. In that email also, it had stated, I could be there in the new year and everything, so we can continue it until then as an option as well. I don't think having a full-on hearing without counsel being present is an appropriate reaction to that. And I don't know how he checks his email, but he clearly did in the record by stating that counsel would not be present. He stated there was an email received, but there was no response.
Let me ask you about the letters of good standing, if I could. The state is arguing that that would be a valid, independent avenue to deny the appeal in and of itself. What do you make of that?
I don't think it is, because the local rule relies on clerk's offices having to submit to an order from a different judge. And personally, I got a very heated phone call from one clerk saying that they don't have to comply with it, even after I sent an order. That was informed to the judge and everything. At that point in time, it's between a rock and a hard place. And in substitution of those good letters, why the record is so big is we submitted semi-annual reports. So we went above and beyond to kind of replace that good letter standing, just show financials, show what bonds were still conditional, show what bonds were still open. So I think at that point, just a letter of good standing wouldn't comply, because a semi-annual report actually gives more information than just a letter of good standing.
Well, a semi-annual report is the report that's filed by the bonding company. It's not a representation from the court in that judicial district that the company is actually in good standing at that point. And you're not challenging the validity of that local rule. Our courts have held that as part of their supervisory authority over bonding companies, that courts may promulgate rules of this nature. So as we stand, that rule has not been complied with, has it?
It has not to this point, but that was also not a reason we were denied. It states very clearly in the order that it was denied due to inaccurate affidavits only. Not because of the local rules, not because counsel was not present. It has that one very specific sentence that it was denied due to inaccurate affidavits. And that's why we contend that that is incorrect, because the affidavits were corrected to the judge's liking as requested, even when we had argument in hearings about the bankruptcy issue.
Is our review de novo?
I am not sure at this point, Judge.
Well, if it is, how would that affect our ability to look at the totality of the record and see if the result of the order was correct at the end of the day, regardless of the specific grounds relied upon by the trial court?
In fact, our review is de novo, isn't it?
I think so.
I think it is.
I think it is as
So-
well.
So if it is de novo, as Judge Hickson is saying, and you can see that there haven't been letters of good standing that have been provided despite the court's request, isn't that a sufficient reason for us to deny the application and affirm based upon de novo review?
I think it is, but in this case, when the court clearly was told of the struggles and went above and beyond to supply it, and it even gave a list of the counties that were not complying. At some point in time, even with the judge's order, we can't go there and force a clerk to write out a letter of good standing. Emails have been provided, proof of communication have been provided. They just outright refused. Not that because we were in bad standing, which is why we did the semi-annual reports in its stead and informed the court that that's why. And they could clearly look to see if we were still doing business in those counties. If we're still doing business in those counties, then we're clearly in good standing and not suspended. That's all.
Thank you, Counsel.
Thank you, counsel.
Good afternoon, Your Honors. Alan Groves on behalf of the state. The trial court properly denied Tennessee Bonding's petition to write bonds because its president lied under oath about prior bankruptcies and civil judgments against him, and because the company concededly failed to comply with the local rule requiring letters of good standing from all surrounding counties. Additionally, Tennessee Bonding waived its right to participate in the hearing by failing to appear or by moving for a continuance, and it cannot show plain error in the admission of evidence at the hearing. This court should affirm. So just to begin with the first issue about whether the trial court erred by denying the petition, this court's review is de novo pursuant to the statute, 4011-125D. And as the court has indicated, based on a de novo review of the record, I think the court can pretty readily ascertain that the company has conceded that it has violated the local rule in this district. And I agree, Judge Hickson, that the proper way to go about this would be to challenge the validity of the local rule itself. And we know that that's possible because we've seen it done in other cases. The Cumberland bail bonding case where a company argued that a local rule was arbitrary and capricious, and that would be the appropriate way to challenge the rule itself. But that was not done here. There was some discussion in the trial court about thinking that the rule is unfair, but it was never really couched as a legal challenge to the rule itself.
Well, what are they supposed to do, though, if they call up a clerk from a neighboring district and they get ghosted and no one's going to provide those letters? They don't have to. It's a different district's rule. That kind of puts them in a tough boat, doesn't it?
It does, and again, if they had challenged the rule, then we could have a more developed record about the process of going about doing that. We would have findings by the trial court about whether that was or wasn't appropriate or arbitrary and capricious, but we don't have that record here. I do appreciate that it's a difficult situation in that regard, but the company has conceded the violation of the rule, and that really should be enough to end the case. But even if it wasn't, we also have the false testimony from Mr. Cole about the prior bankruptcies and the federal liens against him. I still don't take counsel to be disputing those facts. I really only hear her saying that, well, we don't know for sure that he declared bankruptcy or had these liens because we don't know where the documents came from. But that just goes towards the evidentiary areas that they've raised, which are waived and not subject to plain error review because of the tactical waiver. And regardless of which party has the burden on that prong, this is a pretty clear example of how when you don't show up to the hearing and object, it deprives the state of the opportunity to resolve any of these evidentiary issues or authenticate them in another way. Certainly, Mr. Cole could have authenticated, I would assume, any bankruptcy petitions that he had filed in federal court, but because he chose not to attend the hearing, the state didn't authenticate them in that way. So I think they are in the record, they are proof, they weren't objected to, so we can take it that he did declare bankruptcy, that he did have these federal tax liens. And that makes his November 2023 testimony false, because he was asked about these things without any kind of qualification about Tennessee's bankruptcy statute. The bonding statute that talks about bankruptcy, as Your Honor mentioned, that wasn't part of the question. He just categorically denied that he had ever filed for bankruptcy. And same with the tax liens. He was asked about that directly and just denied it.
Go ahead, Judge.
No, you go ahead.
Go ahead.
Please, I insist.
Well, it seems to me, thank you, Judge Hickson, it seems to me that if I'm faced with a question on a bonding application, and I think that the question exceeds what the statute demands that I disclose, I have a choice between maybe two options, maybe more, but I can think of two. One, I can object to the question and to say the question asks for more information than I'm required to disclose. Or two, I can answer it. But the third option I don't have, and that is to answer it and to answer it falsely. And it seems like they picked door number 3 here.
I agree, Your Honor. And my recollection is that Ms. Turin was the one that asked her client this question. I don't even think it was the state trying to elicit more information than arguably the statute required.
Okay.
So it wasn't a game of gotcha that
Right.
the state was playing.
Judge Hickson, I'm sorry.
That kind of touched on
Okay.
where I was headed. I did want to ask you, though, about the hearing, the hearing where that particular testimony was ultimately refuted. The appellant is saying that that hearing shouldn't have happened, given all of the circumstances. What's your response to that?
Sure. And the appellant's brief doesn't cite a lot of law in their argument section on that issue. I sort of took their point to be an argument about due process, that they were deprived of a meaningful opportunity to be heard. I think that's probably the best framework to think about this. But again, as Your Honor noted, I think the appropriate way for counsel to handle this situation, which I admit is very uncomfortable to talk about, and maybe if I was the trial judge, I would have handled it differently, but probably counsel should have moved for a continuance so that there was a formal motion on the record that the court would have to resolve and rule one way or the
Didn't she effectively
other.
do that, though? I mean, she didn't file the motion. It's not in the technical record, not a formal request for a court order, but there's an email that says, I cannot attend. Medically, I cannot attend. And if we're going to have to wait until January to do this if we insist on going forward. And she's putting the court on notice that she's not going to be able to be there. She's putting the court on notice that her client will be unrepresented. She's putting on notice that there really isn't a fair opportunity to be heard, irrespective of whether there's a formal pleading. So effectively, hasn't she done that?
I don't think so, Your Honor. For one, the email's not in the record.
Okay.
So all we have is the trial judge's kind of commentary at the hearing characterizing what the email apparently said. And number two, even if we look at those statements by the trial judge, he says, as I think someone on the panel mentioned, that the email apparently demanded a ruling. And that's not a motion for a continuance when you're asking the court to rule immediately. And I think there's also other filings that the company made prior to this where they similarly asked for a ruling immediately. I think that's the word that they used. This had been going on for several months. I think all parties were kind of frustrated that it was continuing. And so I think when you're looking at the whole record in context, this wasn't a motion for a
Sure,
continuance.
and I see the point about the request for the order. We'd like to have an order just either granting or denying the application. But there are also contemporaneously with that requests that the court hold a Zoom hearing or a remote hearing of some sort. And I'm not aware of any authority that compels the court to hold a Zoom hearing. But the significance of that for me is that she's putting the court on notice that she wants to be heard. I want to participate in the proceeding. I want to be heard. I'm not getting any response from you all, and so maybe just go ahead and send me the order, but I want to be heard. And so I wonder, through a due process lens, as we're talking through here, should the court have continued the hearing even absent a formal pleading?
I think it was within the court's discretion, both to either hold an in-person hearing versus Zoom or to continue it. There wasn't really a motion for a continuance, so I don't think that's really implicated, but I think the court definitely had discretion as to whether to hold an in-person hearing or not. And this was initially addressed at the April 2024 hearing. That was where the initial request had been made, and it was pretty clearly denied at that point. And so the next hearing date was set for June 2024. That gave counsel about 2 months to decide what to do. And if she did not think that she would be able to attend, another option that the company had was to find another attorney that could possibly represent them at the final hearing. They had a couple of months to work those things out. And I think I cited a Court of Appeals opinion where there was a mother in a parental termination case who was denied the right to participate in the final day of that hearing via Zoom. And the Court of Appeals noted in its decision that the mother had quite a long time to arrange some transportation issues so that she could make it, because that was the reason apparently that was given for her inability to appear. And so similarly here, the company, if it didn't believe that it could proceed with its current counsel, could have made arrangements to find someone else. And I think there's kind of an implication in their response at one point that maybe she had been working on the case the entire time or something to that effect, maybe implying that it would just be too inconvenient to retain new counsel. But I kind of take that as an admission that was an available option, even if it would have been inconvenient. So again, I think that's another thing that the company could have explored.
That's
here.
true, but it's also a pretty costly option as a practical matter. I mean, we've all represented private clients. You get a new lawyer comes in, maybe the lawyer's familiar with the bonding practices, hopefully he or she is, have to get familiar with what's gone on before. And so that's an expensive proposition. It seemed to me the easiest thing to have done and maybe consistent with due process was just put it off until January, instead of proceeding with a hearing without counsel who said she couldn't be there and asked to be heard.
And if they had asked for that,
Sure.
a continuance until January, I think we might have a different situation on our hands. But I don't think that's the fairest way to interpret the record, especially in the absence of the actual emails. And just trying to read between the lines about the trial court's kind of characterization of what happened.
That's fair.
We've also advanced this argument, too, that the statute, Section 125, also says that the professional bondsman has the right to appear at the hearing personally, with or without representation. And none of the bonding agents of this company appeared at the hearing, despite the trial court's clear directive to appear. And so I think if I'm reading that statute correctly, I'm not super familiar with it, but it sounds like on its face that the agents themselves could have appeared at this hearing even without their attorney present.
Aren't those agents, though, who have been approved to write bonds in the judicial district, though? Because the reason they're appearing in court is to account for a defendant or otherwise, and that seems to me that implies that those agents have already been approved. Here we're talking about a company that's coming in, and typically in our civil context, a lot of times companies aren't allowed to appear without counsel.
So I don't quite agree with that, Your Honor. I think that the statute that opposing counsel cites, 4011-302, I think that's the statute that does apply to agents that have already been approved by the court. But 4011-125B talks about companies that are also petitioning. And I think it uses the phrase, like if the trial court withholds permission, like withholds or suspends. It uses 3 different verbs there. Okay. And I think 125 does encompass the situation. And so regardless of whether they've been approved as professional bondsmen in other districts, I think it would still allow them to appear personally. But I haven't found any cases kind of interpreting that language from this particular statute. I did want to back up just for a second on the first issue, because counsel has said repeatedly, both in the reply brief and this afternoon, that the trial court's only basis for denying the petition was the inaccuracies in the affidavit. And I just don't think that's the fairest way to read this order that the trial court put down, especially when considered in tandem with the trial court's oral findings. So in the written order on page 612 of the technical record, counsel is really pointing to paragraph number 12, which says that the court finds that Tennessee Bonding Company is not qualified to write bonds due to the inaccuracies in the affidavits. It doesn't say only. It does not say that is the only reason that they're not qualified to write bonds. And I think if your honors read the totality of that order, there's several findings throughout the order about Mr. Cole's false testimony, which the court calls perjury, Mr. Holmes's testimony about not being aware of outstanding forfeitures. There is the comment about the affidavit being inaccurate. But it also mentions that it didn't even hear testimony from Ms. Carnegula, who's also petitioning to write bonds. So I did want to correct that. I do think if the court is concerned with the basis of the trial court's ruling, it wasn't just based on that. But under a de novo review, certainly you would be able to consider these other matters. The last issue is this evidentiary issue, which I've kind of already addressed. We think that this issue has been waived by the lack of any contemporaneous objections. And I think especially here, it's important for this court not to engage in a plain error review when counsel has not requested that the court conduct a plain error analysis, either in their opening brief or in their reply brief. This court recently has made that pretty clear that it's their burden to establish plain error, and you have to start by requesting it, and that hasn't been done here. But in any event, the waiver seems to be pretty tactical in this instance because, like I mentioned earlier, the state would have been able to cure some of these evidentiary issues had there been proper objections.
Can there be plain error in this context? So, I mean, typically, like in civil cases, we don't apply the doctrine of plain error. This is not really a civil case, but it's also not a criminal case where you have indictment and defendants, the protections of the accused. Do we have cases of applying plain error in the context of evidence issues in a bonding approval case?
I'm not sure, but I think our courts have said that the plain error doctrine is kind of rooted in Tennessee Rule of Appellate Procedure 36B, which seems like it would apply in civil and criminal cases.
Yeah, okay.
So yeah, I do think the plain error doctrine probably could apply in this instance. But if there's no further questions, we ask you to affirm the trial court's order.
All right.
Just briefly, judges, I'll kind of go point by point from what he said. The state says that the arguments of a local rule was being capricious and never couched as a challenge. Well, we were never denied due to this reason. It specifically states in the order the reason for denial. So there's no point in getting into whether the local rule was capricious or not, or challenging, because we were not denied for that reason, which is why it was never brought up. Choosing to attend a hearing or not for a bondsman. Obviously, we have two conflicting statutes that both feel apply. We feel 302 applies, they feel 125 applies. We feel 302 specifically lists the reasons when a bondsman can or cannot appear. Obviously, say, hey, where is this defendant? Have you been able to locate them? Things of that nature. But on an application for a bonding company, we feel that they need to have counsel present, especially when one is a corporation. And local courts have ruled on that. They will not talk to bondsmen unless counsel is present. With regard to the objections being waived, when the order came out, there were not a list of exhibits attached. We did not know what exhibits were even submitted into evidence until the record came about in appellate court procedure. So there was no way for counsel to object to the introduction of these exhibits, even at the local level when no record was even submitted to counsel. If there are no further questions, that concludes.
All right,
Thank you.
Counsel. You need a break? Okay. Call the next case, please. Thank you, counsel.
State of Tennessee versus Roy Frazier and Bianca McCaughey.